Okay, it looks like we could start. I'm going to start. Welcome to Alberta Civil Liberties Research Center, what we call brown bag lectures. I guess it's video brown bag lectures. You still have to bring your own lunch, so I guess that's still the same. And today we're going to be talking about some proposed changes to the Police Act and some issues that we've worked on. Before we start today, I'd like to do a land acknowledgement, acknowledging that we're located in the Treaty 7 region of Southern Alberta, which includes the Siksika, Piikani, Kainai First Nations, the Tsuut'ina, and the Stoney Nakoda Nation, Shiniki, Bearspaw, and Wesley First Nations, and also the fact we're the home to the Métis Nation of Alberta Region 3. We are situated on land where the Bow River meets the Elbow River, and the traditional Blackfoot name for our city is Mohkinstsis, and I'm sure that I didn't exactly pronounce it correctly. Forgive me. And today we have two speakers. We have Borsha Mene and Mirnat El-Fakri Tuttle. Both people work at the research center, and they're both presenting. Just by way of a bit of a background, about a year and a half ago, the provincial justice minister, Casey Madu, decided send around a notice that they were going to have submissions on the Police Act. Every few years, they kind of look at the Police Act, and the research center has actually been making submissions to the provincial government regarding amendments to the Police Act since before I worked there, which is in the 1980s. They started, and it's usually around the same issues. More recently, it's broadened out a bit, but the three main issues that the minister sought input on was accountability, issues around racism and policing, and then finally issues around Indigenous policing. And as we have done quite a bit of work in the first two categories and hope to do some work in the third category at some point, we thought you might find it interesting. The only thing is the report has not been released yet. So we'll probably have to do a follow-up seminar once the report with the recommendations comes out. So our first speaker is Borsha Mene, and she is a lawyer, and she works at the research center, and she's going to be talking to you about some aspects of our research regarding anti-racism and the policing and so on.
Hi, everyone. My name is Borsha, and today I'm going to be talking about the first part of this discourse, which is how policing in Alberta has affected diverse communities. So I'm going to start by talking about the different communities we have in Canada. First of all, can you see me?
Yes.
Okay. I'm going to start by talking about the diverse communities we have in Canada. And several others have identified different categories of major communities. For example, Wang identifies three categories. She talks about French and visible minority Canadians, Indigenous people and the British, other Europeans and mixed origin Canadians. Dewin, on the other hand, talks about French, British, Indigenous, and other ethnicities. And the Employment Equity Act identifies three categories, three broad categories: Caucasian, Aboriginal, and non-visible minorities. Now, for the purpose of this conversation, I'm going to stick with the categorization of the Employment Equity Act. And I would also like to point out that in modern times, people have interchanged non-visible minorities with racialized communities. So there is a school of thought that argues that Aboriginal people, that's First Nations people, should be considered racialized community in Canada, but that is still in the works. Most authors have not adopted that classification. So I'm going to be restricting this conversation to mainly the effects of the police on racialized, that's non-visible minorities in Canada, including First Nations people. So I would like to also point out the difference between racism and racial discrimination. These two terms are often used interchangeably, but racism is morally reprehensible, but not necessarily illegal. It's a belief by a group of people, a person, that one race is superior to the other. And racism only becomes illegal when there is an element of power as well as racial discrimination. So for example, a person who walks up to a lady walking out of an apartment building and says to her, "Oh, I saw you steal." That's how people of your color behave. That's a racist behavior. But when a person says, "Oh, people of your color steal all the time, and as such, I cannot give you this job," that's racial discrimination. So that's the difference. And that's where, for example, cancel culture comes in. When people are accused of racist behaviors, they're not necessarily charged or accused of crimes. They have only, touched on people's moral conscience in terms of their behavior. Now, existing literature says that racialized communities in Canada have suffered a lot of hardship from the police in terms of, for example, in terms of forced arrests and ill treatment during arrest, excessive use of force, and so on. I would also like to point out that racial discrimination is illegal and is prohibited by federal and provincial laws in Canada. So for federal laws, I would start with the Charter. The Charter in section 7, 8, 9, 10, and 15 prohibits racial discrimination. So section 7 talks about everyone having the right to life, liberty, and security of the person, and the right not to be deprived of that right except in accordance with the principles of fundamental justice. Section 8 talks about everyone having the right not to be secure against unreasonable search or seizure. And section 9 talks about detention or imprisonment. It says that everyone has the right not to be arbitrarily detained or imprisoned. Now, section 10 talks about arrest and detention as well. So it says that everyone who is arrested has the right to be promptly informed of the reasons for their arrest, the right to retain counsel without delay, and the right to have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. Also, the Criminal Code has similar provisions on arrest and detention. Now, the Canadian Multiculturalism Act, which is also a federal law, talks about the fact that everyone in Canada must receive equal treatment and equal protection under the law, while respecting and valuing their diversity. Another federal law is the Canadian Human Rights Act. The Canadian Human Rights Act prohibits discrimination on the grounds of race, national or ethnic origin, color, religion, age, sex, you name it. So any situation where a person is discriminated against by any government body, it contravenes not only the Charter, but also the Canadian Human Rights Act. So provincial laws have similar provisions. For example, the Ontario Human Rights Code talks about the fact that everyone should be given equal treatment. And occasionally the conversation has come up on whether law enforcement agents' actions while carrying out their duties contravene sections of the Ontario Human Rights Code. Also, the Ontario Anti-Racism Act provides that the Ontario government review anti-racism strategies every 5 years. Now, coming to Alberta, just like the Ontario Human Rights Code, the Alberta Human Rights Act prohibits discrimination based on color, race, ancestry, and place of origin. Now, in a case, a 2008 case, Coward versus Alberta Human Rights Commission, this came up. The complainant had mentioned the fact that he was discriminated against based on his race. And the Alberta Human Rights and Citizenship Commission had to outline what would, determine a racial discrimination in terms of the police carrying out their duties. Although in this case, it was held that the actions of the police here were not racially motivated, but the Alberta Human Rights Commission was able to draw out a fine line between what constitutes racial discrimination and what would ordinarily be the course of duty of a police officer. So, like I mentioned earlier, research indicates that some actions of the police against communities are racially motivated. So there is an extensive history of disproportionate policing of Aboriginal and racialized communities in Canada. For example, excessive shootings, as far back as 1988, they were in the Toronto area. Some people were shot, like Michael Wade Lawson, for no reason except the color of their skin. Also, this pertains to a person not of color or racialized, a racialized member of the society, but a white person who was shot and killed by 5 Calgary policemen in 2015. There was excessive use of force as well. Next, I will be talking about treatment, okay? So research indicates that white accused people are more likely to receive preferential treatment in prison, unlike their Black counterparts. And also research indicates that racial profiling and stereotypes exist in the police force. So for example, R versus Singh involved a police officer, and it was held that the fact that he was a police officer couldn't save him from racial discrimination just based on the color of his skin. And excessive use of force. So the Sharon Abbott case, which happened in Ontario, it was held that racism was a motivation for the forceful arrest of Miss Abbott. And moving on to a member of the Asian community, Mona Wang, she was handcuffed, she was beaten, she was dragged on the hallway and spat on by a Kelowna RCMP constable because of her ethnicity. It's also been revealed in research that Caucasian accused are more likely to be released on bail, unlike their First Nations or Black counterparts. So for example, in a survey conducted, it was revealed that in drug-related offenses, the police were more prone to release Caucasian whites than they were prone to release Black people or colored people or First Nations. Another thing that has been pointed out, another trend is under-policing and over-policing of First Nations people. So under-policing, there's been lots of complaints, and even in a survey conducted by the Human Rights Watch, Indigenous women complained that their police complaints were sometimes ignored based on their race. And there are also instances of over-policing where Indigenous women were police victims. For example, there was forceful, excessive use of force in arrests. Pepper sprays and tasers were used to restrain them before placing them in detention. There have also been instances of strip searches, the process of being detained in holding cells for a longer period than they should have been held. And another thing that has happened is the overrepresentation of Aboriginal people in the criminal justice system based on their origins. So cases that illustrate these are R versus Williams and R versus Gladue. So next, I'm just going to talk about recommendations. Due to the research that exists on, the behavior of the police towards racialized communities, there have been several suggestions which were discussed in the report we have on this that's yet to be published. And one of this is procedural justice training for police officers. The report talks about the difference between systematic racism and systemic racism. Systematic racism is actually easier to handle because it could just refer to a person's ideologies. So someone comes into the workforce, for example, with the belief that one race is superior to the other, right? That's just one person. That one person can either be fished out or changed. But in systemic racism, the entire system is corrupt. It's institutionalized. It needs more work. And that's where procedural justice training for police officers comes in. If the system is already bad, there has to be a complete overhaul. And one of the process would be procedural justice training. Another recommendation is to strengthen the communication skills and relationship building between police officers. So if there is a case of a mechanism where other police officers are encouraged to come forward to report bad behavior, racist behavior by other police officers, it might be able to change things to a certain extent. Then another recommendation would be to promote the use of force regulations and policies. So here, there would be an internal mechanism where police officers would be held accountable for racist actions. And examples of this include administrative leave without pay, and administrative leave without pay. Another example would be a situation where these police officers have to write a report and go through a certain review process where they are checked on and monitored from time to time to see how they've reformed their attitudes. Then another recommendation is internal policy and external policy review focused on reducing systemic discrimination. So that would come in where civilian oversight and review agencies will be strengthened to account for police accountability. So for example, review agencies, 2 review agencies that are designed to ensure police service accountability include the Calgary Police Commission and the Alberta Serious Incident Response Team, ACLRC. Although these 2 bodies have been able to review some certain police conduct in the past, there is a concern regarding the fact that they do not have jurisdiction in terms of grievous bodily harm or incidents where people have reported deaths as a result of police conduct. So that is those are 2 areas where bodies like the ACLRC and the Calgary Police Review Commission have a certain deficiency. They're not able to talk about the fact, they're not able to review the conduct of police where grievous bodily harm occurs or where death occurs. And that's one way, when all of these bodies are restructured and kind of like worked on, they will be able to do this, and that could promote the cause of reducing racial discrimination in Alberta. Mena will be talking more on that, and that's all I have. Thank you.
Linda, you are muted.
Sorry about that. I was just going to say we'll leave the questions until the end. And I wanted to mention that both the Calgary Police Service and the Edmonton Police Service have been quite open to giving us access to their statistics and so on in the course of our research. And we would like to continue working with them as much as possible. So is this your PowerPoint that's up there now?
No, it's still Bocha. Bocha, you need to stop sharing.
Oh, okay.
Mirna is our research associate. And there you go. She stopped sharing.
Okay.
Ta-da!
Here.
Go ahead, Mirna.
Okay, so I'm going to talk about police complaint process. So basically, my presentation is focused on the Police Act and interpretation and reinterpretation of the Police Act, which have been taking place in different instances. So my presentation is based on our report. Our report is available on our website. The report was entitled Appeals from Complaint About Police, Powers of Review of Alberta's Law Enforcement Review Board. So I'm going to start talking about the police complaint. What do we mean by police complaint? So police complaint can be made by any member of the public about the conduct of police officers. So here we're talking about conduct. We're not really talking about death in case there was a death or serious injury. And that's why I picked this example. Probably many of you heard about MLA Phillips, who filed a complaint against 2 police officers who admitted to surveying her in 2017. So after filing the complaint, both officers were demoted. So basically, this is what I will be talking about. Again, I'm not talking about a case of death or serious injuries. That would be a totally different process. So the police officer conduct in Alberta is managed by the Police Act and the Police Service Regulation. So we have three types of complaint. We can complain about the conduct of police officer, we can complain about the conduct of chief of police, or we can complain about the police policy or service. So as I mentioned before, any person from the public, whether directly affected or not, can make a complaint. And we say this person has a standing to file a complaint against a police officer. So complaint must be filed within 1 year after the incident takes place, or 1 year after the person was supposed to know about the incident. So if we file a complaint against a police officer, it will be up to the chief of police or what we call presiding officer to decide on that complaint. Presiding officers are current or former police officers that are appointed by a chief. So they're all police officers.
Nice.
So under the Police Act, the chief of police basically investigate the complaint and determine whether there should be any disciplinary actions. If the chief of police finds that the complaint is serious enough, then they will ask the presiding officer to conduct a hearing. When the presiding officer conducts a hearing, they hear facts and evidence presented by the police officer who's involved in the incident and the presenting officer. So the presenting officer is the officer who is appointed by the chief of police in order to bring the case on behalf of the complainant. So the presenting officer is the one who presents the evidence on behalf of the complainant. After a decision is made either by the chief of police or presiding officer, the complainant or the involved police officer can appeal that decision. They have 30 days. So they appeal it to the Law Enforcement Review Board, which I'm gonna call here the board. So, and this is basically what I'm gonna be focusing on. It's like the role of this board, because this is where the interpretation has taken place. So the board was established under the Police Act. It is a quasi-judicial body, and it's supposed to provide independent and impartial civilian review. Why do we call it civilian review? Because the board is made up of people who have expertise in the community. So all civilians, and they are appointed by the Governor General. So no police officers are involved here in this process. And that's why the role of this board is very important. So since 2010, the powers of the board have changed significantly. So what happened is that the Court of Appeal in Alberta and the board itself reinterpreted the role of the board under the Police Act. So before 2010, the board used to have a lot of authority. The board used to conduct what we call a de novo hearing every time there was an appeal before it. What do we mean by de novo? De novo, it's a Latin term, means new, meaning the board will have the right to conduct a new hearing. So a new hearing takes place based on what we call a standard of review correctness. So how does that work? When the board decides on having a new hearing, they hear the fact and evidence that were submitted in front of the police, chief of police, or the presiding, but they all presented by the complainant. And based on that, the board will decide on the matter. If the board agrees with the chief or the presiding officer's decision, then the board will declare the decision correct and will go for it. But if the board doesn't agree with the decision that was made by the chief or presiding officer, then the board will declare the decision incorrect, and the board will decide itself on the matter.
Excuse me, Myrna, you're,
Again,
it's,
2010. So
you've got, it's kind of
what's
broken, you're breaking up.
2010. So what in 2010, two cases of the Court of Appeal that reinterpreted the Police Act. So the Court of Appeal in 2010 said that the Police Act basically doesn't allow the board.
Myrna,
Yeah.
It's, you kind of broke, you're breaking up.
Oh, I'm sorry about that. I believe someone has their microphone on. Can you hear me now? Linda, can you hear me?
Yes, it's a bit better.
Portia, can you hear me?
Yes, I can hear you.
Yes, it's a bit better.
Can you hear me now?
Yes, I can hear you.
Okay, so do you want me to go back or shall I keep going?
Could you go back about 3 or 4 slides, please?
Okay, let me go back here. So I'll go back to the here where we talked about the board. Okay, so the board is quasi-judicial body, and it provides independent and impartial civilian review. I said that we say civilian review because the board is made up of people who have expertise in the community. So they are all civilians and they are appointed by the lieutenant governor. So none of them is a police officer. It's you know, it's something different from having a complaint decided by the chief of police or presiding officer. So in 2010, the powers of the board have changed significantly. What happened is that the court and the board reinterpreted the authority given to the board under the Police Act. So before 2010, the board and the Court of Appeal here in Alberta said that the board will have the right to conduct a de novo hearing once there's an appeal before it. What we mean by de novo? De novo is a Latin term that means new. So the board will have the right to conduct a new hearing. So, and the board used to do that based on what we call a standard of review of correctness. How did that happen? So when the board decides on a new hearing, the board will once again hear the fact and evidence that were presented during the initial investigation or hearing, and will also hear evidence presented by the complainant. So here we're not talking about the presenting officer anymore, we're talking about the complainant. Based on that, the board will decide on the matter. If the board agrees with the chief decision or presiding officer's decision, then the board will declare the decision correct and will go for it. If the board reach out a different conclusion from the chief or presiding officer, then the board will declare the decision incorrect and the board itself will decide on the matter. So that was before 2010. In 2010, we had 2 cases before the Court of Appeal in Alberta, where the court said that the Police Act actually doesn't give the board the right to conduct a de novo hearing every time there's an appeal before it. So since those 2 cases, the board has decided that basically it will interfere with any decision made by the chief or the presiding officer as long as it's unreasonable. Unreasonable meaning it's not based on any logic or reason, and that doesn't happen very often. So they made the job of the board very difficult. So, and since the board had to rely on that review, the board now has little ability to intervene in the decision made by the chief or the presiding officer. So by minimizing the role of the board, the Court of Appeal restricted police complaint to an internal system of investigation, adjudication, and discipline. Internal system meaning police officers are investigating other police officers. No civilians basically are taking an important role in the process. So in 2004, we had a case in front of the Court of Appeal where the court said that the board has the right to supervise the powers of chief and presiding officers in order to make sure that they are not abusing their power. So that supervision assured the public that the whole process, the complaint process, would stay fair and impartial. Despite the involvement of the police, we said that police officers investigate police officers. So the fact that the board had the right to supervise those decisions gave the public some trust in the whole process, but not anymore. Since the board now has to rely on reasonable standards of review, the board cannot supervise the power of the chief and the presiding officer. So now complainant cannot basically participate directly in the complaint process, and the public has lost any trust in the whole complaint process. So in our report, we made two recommendations, one a long-term and one a short-term. For a long-term, we talked about further research and the efficacy of the police complaint system. So we suggested the creation of a panel to further research the issues. The panel should basically have the support of the government here in Alberta, where the panel will have access to police complaint files, investigation, the police, the panel will have also the right to have consultation with some stakeholders and the public. So, and the panel should conduct an in-depth analysis of whether the whole system is efficient or no in order to resolve those complaints. The second recommendation, which is short-term recommendation, is to codify the novo appeal hearing to the board in the Police Act. That means that the Police Act should be amended in order to give the board the ability to hold the novo hearing when they have an appeal before them. And that basically can correct many of the issues that we are facing right now. So finally, the Police Act should be amended in order to set out factors to determine whether the novo hearing is to be used by the board and allow the board itself to decide whether it should use the novo hearing or no. So, and this is my presentation and I'm ready for your questions. Thank you.
Well, thank you very much, Mirna. And thank you for going back again. It was much clearer the second time around. And so we can open it up to questions. You can either put your question in the chat or you can raise your hand. And hopefully I can see that you've raised your hand. And we'll go from there. So. Trying to see. I can't tell if there are any questions or not. Oh, Isabel. Thank you, Isabel. It's always hard to go first.
Hi. I am wondering about, thank you so much for those presentations. They were great. really informative. I'm wondering about the situation with Counselor Sean Chu and the appeal process that the victim attempted to make. And I understand that this was like more than 10 years ago. So I'm wondering why the system kind of failed her in her appeal process, if we're familiar with the fact of that, or if we have any other thoughts about that whole situation and kind of what can be done to rectify it moving forward. Thank you.
Who would like to take that one? Is everybody here familiar with the allegations that when he was a police officer, now he's a counselor, Chu was alleged to have inappropriate contact with a young, what turned out to be a 16-year-old person. And I guess there were some consequences for that matter. He was certainly not severely disciplined for it. And of course, I think he's getting more feedback nowadays than he did back then. And so she's just asking you about your opinion on that.
Well, if the board authority hasn't changed much, maybe we would have maybe we'd have seen a different outcome of the complaint, but just since the board doesn't have much authority anymore, so that's why we're stuck with whatever we have now. So, but we will see what's going to happen. I Googled it many times to see what was going on. It has been in front of the board, but not much has been decided upon. So I hope that answer your question.
If I can just wade in, I think this is an example of a case where we have failings of the system, and where the failings of the system are demonstrated by the lack of procedural fairness and ability of people to do a de novo appeal. It's one thing to say, well, they did, they crossed their T's and dotted their I's and everything looked fine. It's a whole nother thing if they revisit what happened in the scenario. And it's so interesting. Like, my understanding is that this never came up when Mr. Chu was in the council before. So it's fascinating that it came up now, and he certainly is in the court of public opinion. I think it's fair to say that he's certainly that's an issue. But thank you for asking that, because that's a pure example of what we're saying, is that the process has some flaws and the board's hands are tied. And it's interesting in this case because the court is the one that tied the hands of the board, not the until the court ruled that it wasn't de novo, it was always de novo. And so we've been asking the government to please revisit that court decision and revise the Police Act to make it clear that we want to go back to the old system, because at least then they can look at all the evidence and not just the procedure. So we have a question here from Janice in the chat, and it says, the Canadian Census identifies many backgrounds: European, Central American, Filipino, Chinese, American, Chinese, Asian, South Asian, Southeast Asian, and Black. So therefore, Canada has no citizens of African descent. Every other category is based on a country, but African descendants are identified by color. Is this not systemic racism or discriminatory in itself? Who wants to take that one on? You need to put your mic on.
I will take that. I did see the census categorization, and I think it's really odd. And that's one of the issues we're talking about. There is a lack of representation of certain communities, and the Black community, one of them. And what you pointed out is an issue of systemic racism. And that's where recommendations come in. That's where people who belong to these communities and people where these communities work, let's use Black as an example. People of Black descent who work in certain institutions have to come up to mention this, and those institutions have to take their concerns into consideration, because it's a matter of systemic racism. It's embedded in the system. It has to be overhauled. So thank you for pointing that out. It's a problem that needs to be worked on.
Thank you. And Janice looks like she has something further to say.
Yeah, I'm just, it always amazes me, because if you look at so-called Black people, and yet you have Europeans, what happens when people who have, relocated from an African country and to anywhere in Europe, and then they go from Europe to Canada? What do they identify themselves as? I mean, the whole system is so ludicrous. It just boils my blood, sorry. But, and I think that it goes straight from the government at the highest levels. So that's something that I think needs to be really worked on, because I think, yeah, obviously. And the same thing goes with, okay, what about people from the Caribbean?
They're not on there.
Like it's just ludicrous.
And
thank you.
To draw a parallel, a little bit off topic, but not really off topic, because we've done work on racial profiling, and I've had several meetings with the police talking to them about, like when you go up to somebody and you're carding them and you have to identify their race, and their solution seems to be, it's still asked, because I had to phone the police about something, and they actually asked me what race I thought I was. And I thought, oh, that's interesting. Like, they're trying to be more inclusive, but I think it's really a problem when they are the ones that get to say what the race of the person is. Like, there are many people of very different mixed race, and people of who identify one way or the other. And it's, I think it's a dangerous idea to have the police be the sociologists, or whatever you want to call it. It's a problem. And sorry, go on, Janice.
I was just going to say, also in the prison system, it's even more bizarre, because there you can be white, Indigenous, or non-Indigenous.
Yeah.
Or
you could take, if they had a box all of the above, maybe it might work for some of our Canadians, because people come from very diverse backgrounds.
Yeah. Anyway, that's my point. Thank you.
Yeah, it's interesting, because if the police are trying to make themselves more aware of what's going on, the first thing they have to do is be very clear about who we're talking about. Any other questions? Let me see. No, nothing down here. Comments? Don't see anyone.
Maybe if I could follow up on this police accountability piece for Councillor Chu. In her appeals of the internal review process, the victim was alleging kind of the systemic cover-up by other cops. And it's also my understanding that the cops had like a publication ban, which is why it hadn't been reported on until recently. And I'm wondering about accountability for these kinds of complicit actions in covering up violence or enabling violence that, you know, aren't really going to be subject to a disciplinary board because there's not like one specific victim, but like there's a whole bunch of people involved in the cover up. And like, if you have any recommendations or ideas about what that kind of accountability process can look like moving forward, because it doesn't really seem like there's a location for it to slot into.
I believe I listed that as one of our recommendations, a system whereby police officers will be encouraged to come forward to report bad behavior. Of course, since my presentation was centered on racist behavior, I didn't really touch on conduct concerning, I didn't really touch on sexual misconduct, but it goes like with the same flow. If there is a system where officers will be encouraged to come forward to report, and there will be a show of shame regarding such behavior, it will definitely reduce things like that, things like sexual misconduct or racist attitudes. The reason why all of these are still going on is because there is a system in place where people are not held accountable. So there is a cover up. For example, if the person is a senior officer, junior officers might not want to be picked on after telling all of this, whatever they know regarding incidents like this. So that's where the internal review process comes in. If there is a system where racist behavior and other sorts of misconduct are monitored, people will be encouraged, other police officers will be encouraged to come forward.
It's a systemic problem, and it's also a cultural problem for the police, and it's a long-standing problem. And I think one of the biggest developments that I had concerns about in the beginning, but now I'm starting to think maybe not such a bad idea, is video cameras and a lot more taping of encounters with the police, because we've seen some really bad examples actually of quite serious abuse, and they were taped. And I think that there was a public outcry, and the police had to do something about it. I think when things happen behind closed doors, they can cover up for each other, and it's not as easy to prove that these things happen, and especially since they back each other up. And there's, you know, it's not encouraged to step up. So it's a whole systemic change that needs to happen. We made another submission to Minister Madhu about the whole system and how it's going to take a significant overhaul. And I would say around anyism, it's not just racism, it's also sexism and so on. I think it's a major deal. Like, the idea is, you know, we don't get rid of the police, but we need an overhaul. We need a serious overhaul. Not to mention, I didn't even talk about mental health issues and dealing with people who are having mental health problems and how that should be dealt with. And but I'm really encouraged that the minister is interested in looking at it. But I'm a little bit jaded because this is about the 4th time we've made submissions on changes. And let's hope this time they actually listen to us.
I can add something. It's, I mean, the whole system is wrong, right? The internal system. So they basically put the board aside and said, you guys go investigate each other, right? And that's why we see like most of the, you know, these officers get acquitted, never get convicted, because there's no one on top to supervise that. And this is what the board used to do. So now they just, you know, left it up to the like the police department, if you want, to, you know, to investigate this complaint. And it doesn't work. You need someone on top of them to supervise what's happening. So, and that's why we need, again, to go back to give more authority to the board in order to investigate, and supervise what's happening.
And
Exactly.
if I can also add to that, there might be some sorts of
Exactly.
there might be some sort of, sorry, I was a bit distracted, I was reading that. There might be some sort of preventive mechanism. So all of this has happened, there are lessons learned, and there must be some sort of, policy that states out there the reward for such behavior from the onset, so people know. And if people, like, if those errant police officers are made scapegoats and used as examples, presented to the public for us to know this is what was done and this was the steps that were taken to punish those officers, that might also have a very, very big impact on the problem. So these officers are identified, they are cautioned, and the public is made aware of what has gone wrong. That is a preventive mechanism to prevent other people from doing such things in the future. So one way could be to prevent such actions from actually happening and punish those people that have, taken such steps.
So Janice says we need the internal system is not accountable. And I think that's been the ongoing thing that's been said about the police investigating themselves, that's a flawed system, that you need to have external. Now they do have a person who keeps track of all the complaints, and the person is not part of the police force, but all they do is sort of keep track of the complaints and the outcomes in a generic sense, not naming anybody in particular. And that's been going on for a long time. And so gives you some idea of what's happening, but it's very neutral. You don't know who the person is. They're very well protected from any scrutiny. Okay. It's going to, I encourage, I'm encouraging everybody, if you come, we'll certainly let you know if you want, when the report of the hearings comes out. We were certainly thrilled that the minister took our reports into consideration and said he did, wrote me a letter. That's encouraging to us, but I want to see what the outcome is. And I guess if nothing else, Mr. Chu is an example of how the public now knows what happened, and there seem to be some consequences, like the mayor, the lady mayor, Mayor Jody, sorry, I don't know how to pronounce her. I better get on that. Jody refused to swear him in. So that's interesting. She made a point of saying, no, I don't think that would be appropriate for me to do. So I think there are prices to pay. It's not exactly probably the way we would like it to go. It should have come up a lot sooner than it did. But any other questions or comments? In fact, please make sure that you get on the list to be notified when this racism report is finished. We did a lot of work with the police and a lot of consultations back and forth, and I'm really encouraged by that, because that would make me very happy that they are willing to work with us and take some constructive criticism from us. Well, any last words from our two noble speakers? Well, I appreciate all your hard work and your presentation today and all the hard work of the students at the research center. You know, the police in our society have a lot of power, and they're also needed to keep us all safe. So we have to make sure that we keep our pulse on the developments. And so as soon as we hear something more, and when our reports are ready, we will definitely make sure everybody who was here today knows about it, unless you don't want to. Won't force it on you, but. And the minister. Okay. Well, guys, thank you for all your hard work today, for doing this.